From the BG Ad Group studios, this is a special Paulding County News Election podcast with your host, Melissa Carter.
Angela Woodall joins us now. She is running for re-election for Paulding County Probate Court. I should call you Judge Woodall. I apologize for that. How are you today?
I'm great. How are you doing? And Angela or Angela Woodall or Judge Woodall, anything's fine.
Sounds good. Well, I appreciate that. Now, a lot of us have been part of probate for one reason or another, but explain a little bit about your position as judge and what you cover.
Just a little background. There's 159 probate courts in Georgia, one in each county, and probate court handles primarily estates with wills, administrations of estates without wills, guardianships of minors and adults, conservatorships of minors and adults, emergency hearings of minors and adults, and anything that involves an estate of someone deceased. So that's a lot to say, but anything that involves probating an estate, whether the decedent had a will or not.
And that's probably why a lot of people have been part of probate court. I know in my personal experience, not in Paulding County, but when my mother passed and we had to make some changes in the will, right? Because it was COVID. So we had to make a few changes of some of the things that she said. We had to go through probate court in order to have that done officially and that kind of thing. So I'm assuming most people have dealt with probate when it comes to the death of a family member and how important it is to have a will. I'll say that. That's
yes.
Because that's something. Well, let me ask this question. So Judge Woodall, what advice would you give the listener when it comes to making sure that in their life they have what they need in case probate is a part of their future?
Of utmost importance and makes their life as well as the court process much easier is if everyone had a will, which of course most people know that is what your wishes are after you pass away. And it can be a simple will. It doesn't have to involve a lot. You need an executor. You need a trustee if you have a trust. A lot of people don't, but you need a trustee if you do. You need to lay out your special bequeaths, things you want to leave to loved ones or friends or family, and maybe what to do with your real property. And if you do that in a will, then it's very clear to heirs and beneficiaries what your wishes are, and it's very, very difficult to have that objected to. Now, the flip side of that is an administration where you pass away without a will. That opens up a lot of doors to, for lack of a better way of putting it, arguments, litigation, difference of opinions, and an administration is where someone passes away without a will, but they have an estate, such as a house or retirement accounts or savings accounts or cars. And the loved ones or nearest relative cannot make those disbursements for that decedent until an administration is filed. But it's a much more difficult process in managing that and reporting to the court annually, more intrusive process. Can it be done? Of course. Can people manage administrations pretty effectively most of the time? Yes, but it sure makes for a much easier process if you have a will.
I mean, I could ask you all kinds of questions about the drama you've seen, but I'm just curious, one last question along those lines, kind of a ballpark, how many years have you seen it take for that to be resolved for people who didn't have their paperwork in order before they passed?
Oh, goodness. My court, I do take a little pride with my clerks in when somebody files an administration, and a lot of people try to file on their own, which there's nothing wrong with that, but it can be very difficult. And oftentimes they end up needing to at least consult with an attorney, if not hire one. The problem with administrations is they can be resolved as soon as about 90 to 120 days. But many, many, many petitions for administrations are litigated because of the differences in opinions and what heirs believe or what the beneficiaries believe, or an heir believes that a beneficiary shouldn't receive something. Lots of times caveats and objections are filed, and that can cost a lot of money and not be resolved for maybe over a year to 2 years. We like to resolve probate cases as swiftly as possible because so many people's lives are affected immediately and for quite some time when somebody passes away. So my court, I do not like to let them linger. I will hold the attorneys accountable for pretrial orders or status hearings. Where are we? And get the cases moving along. But lots of litigation and lots of aggravation can be had in administrations where the decedent didn't pass on their wishes.
And I'm glad you brought up the language of your courtroom and pushing those lawyers along, because I think for a lot of people, if they're not exposed to the courtroom very often, they know a judge oversees and makes decisions in the courtroom, but you also kind of have to be the referee and also regulate what's going on with the attorneys that appear in your courtroom. Because your background is in family law, I know.
Yeah.
Talk a little bit about that part of your job and why people should vote for you.
From practicing law for over 20 years and being a solo practitioner, you're always looking for efficiency and moving files along because you don't want to disappoint your clients. You don't want them to be upset with you. So you learn over time to manage files concisely and precisely and efficiently to get the best bang for their buck for your client. And the same thing kind of applies here in probate court is we have a system in place. Certainly there can be flaws in it where at least annually for post-judgment files, as well as monthly monitoring current files for progress. My clerks are responsible for keeping a monthly list of statuses of their files they're managing so we can make sure that a file is not getting lost in the cracks or an attorney has just let it lay and hasn't followed up with the court. We will notify attorneys. And let me say this, most of the attorneys that work, at least in my court, are extraordinary because probate is such a finite, refined, weird little niche in the law. You either know it or you don't. It's not something you can just dip your toe in every now and then because it's very statutorily driven. You've got to know the statutes. You've got to know the forms. You've got to know what they mean. You've got to know how to fill out things correctly. And 90% of the time, the attorneys that practice here are phenomenal. And they as well don't want their client's case to be delayed because everyone's suffering over the death of someone. The longer it's drug out, the worse it is for them. And so we all kind of take on that same aspect of wanting to move it along. But we nudge them along when we have to. We'll email them or write them a letter and say, hey, the judge needs a status in this. Or we'll have a status hearing and say, okay, counsel, let's talk about where we are and why it's not moving forward. I think we have a pretty good management on those files. And the last thing that we want is somebody to call in and say, hey, nobody's called me, or I don't know what's going on with my file, or it's been 2 or 3 months since I've heard anything. That should rarely happen because I think we have a pretty good management of the files in place.
Well, being a judge, it's very time consuming. So my last question, Judge Woodall, is what does it take when it comes to an election as a judge? How much effort are you able to do? And is there a different type of way to handle an election and to promote yourself because you're in such an esteemed position?
So running an election, which I've had to do, planning ahead of time, gathering your marketing strategy and your advertising strategy and creating a team around you to help you is extremely important. Whether it's a small county election, I've said this when I first ran for election, whether it's a small county election, a state level election, a district election, a national election, I don't know how anybody does anything bigger than a county election because it took everything out of me possible to, well, number one, I campaigned during COVID. Oh, right. So that was a whole, waving from curbs, giving out information from far away, walking past businesses and talking to people from windows. Be that as it may, COVID or not COVID, can be a very expensive process. It can be a very daunting process. But if you want to run for election, you need to start organizing yourself, if you can, at least a year ahead of time, so you have the best resources around you to do that.
The primary is May 21st. We encourage everybody to get out there and vote. We
Yes.
appreciate your time, Judge Woodall, for being with us, and good luck this spring.
Yes, thank you so much. And everyone, please go vote. I appreciate it very much. Thank you for having me.
Thanks for listening to this special election Paulding County News podcast. Stay tuned for more interviews with our local political candidates.
Life's a constant hustle. And at Credit Union of Georgia, our focus is crystal clear. It's all about you. Juggling a million things? We get it. That's why we're committed to providing the best service imaginable. We're not just your credit union, we're your financial allies. Knowledge is our power, from crafting basic budget plans to navigating the local home buying scene. Questions popping up? We've got you covered with fast, friendly answers. Because we want you to spend more time living your life. Imagine a financial institution that truly cares. That's Credit Union of Georgia inviting you to join us. If you live, work in Bartow, Cherokee, Cobb, Dawson, Paulding, Pickens, or Union County, we want you as a member of Credit Union of Georgia family. Because here, you're not just a member, you're part of a community that cares. Ready to experience banking that revolves around you? Call us at 678-486-1111 or visit cuofga.org. Credit Union of Georgia. Your financial journey, our priority.